Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. One of the multiple motions to suppress evidence Mr. Kohberger filed on November 14th, 2024, was his motion to suppress and memorandum of law in support thereof relative to the Pennsylvania search warrant for, and he provides the address of his family home where he was on the date of his arrest, and statements made that accompanied that search. Mr. Kohberger provides, I think, a rather interesting recitation of the key facts of the case that are, for want of a better terms, easy reads. It doesn't have a lot of the legalese that we see further on in this filing. So if you read the first 3 pages of this filing, you'll get a sense of what at least the defense believes the basic facts of the case are leading up to this motion to suppress. They make a couple of fascinating, I think, legal arguments that Judge Hippler will have to now deal with, whether or not he's calling this, Mr. Kohberger, basically a warrantless search, that the arrest warrant in Idaho could not have given police in Pennsylvania the authority to enter the house. In other words, what he's arguing here is that but for the Idaho arrest warrant, which was rendered on December 29th, 2022 by Judge Megan E. Marshall, the magistrate, who also happened to be the jurist in the first several months of the case before it was transferred up to Judge, that warrant, but for that warrant, the warrant in Pennsylvania could not have been issued because Mr. Kohberger was not deemed guilty of committing any crimes or even thought to have committed any crimes in Pennsylvania. If you read the Pennsylvania documents, and I've provided you a link in the description to this podcast episode so that you can go to Commonwealth of Pennsylvania and read the Pennsylvania probable cause affidavit and all of the warrants that were issued that relate to this Idaho warrant. So what they're saying here on page 8, the Idaho arrest warrant could not have given police in Pennsylvania the authority to enter the home. He continues on the next page and says, state warrants have no extraterritorial effect, citing to State versus Bradley, which is an Idaho 1983 Supreme Court case. Then he states that the use of an out-of-state warrant is ipso facto a warrantless entry. So basically, this is a warrantless search, an entry into Mr. Kohberger's family home. He also addressed the issue that even though this was not his home, he was there on an extended stay, staying with his parents while there was a break in classes, as many students do. They go home for the holiday season between mid-December to beginning of January or so after the New Year's, when the spring or the winter semester, depending on what college you're looking at, commences. He's saying he has standing to challenge this warrant, even though it's not his home. He doesn't own it. He's not one of the owners, apparently, on the deed. But just as typically when a person, let's say, rents an apartment or a room or is in a place for several days, he's arguing he has standing. He has the ability to challenge this warrant. Now, the issue of standing was used in this case before. You'll recall that when the interveners, aka the Media Coalition, went to the Idaho Supreme Court in an effort to set aside the non-dissemination, aka gag order that was put into effect in Latah County, the Idaho Supreme Court said, yes, you have standing to raise this issue because you're the media under the First Amendment. You report on cases like this. However, you should have gone to Latah County first. So that's the issue of standing. Do you have the right to raise a legal issue in your own name or not? He's saying he does. If you'd like to review this document, and I very strongly recommend that you do, please go to the link that I have provided in the description to this podcast episode, and you can do so for yourself. Thank you, as always, for joining us here today.